Now come to order.
At our hearings over the past
Without
few weeks, a number
objection, the
of
chair is
Republican
authorized to
members
declare a
raised
recess of the
serious
hearing.
concerns about the WTO consistency of the original
The
version
the,
of H.R. 2378.
integrity
As a
of
result
our
these
judicial
concerns,
system
Chairman Levin
relies
completely
on the
rewrote the
promise
bill.
of access
The
to
version
justice
before us
for all
today
Americans.
has little in common
A
with the
central
original,
tenet of
which on
that
its
promise
face
is that the
violated
public
our
must
WTO
have
obligations.
trust
It addresses
that
many of the
whatever
criticisms
they
raised
need
by
or
witnesses
whenever they need
and by
access to the
Republican members, and I
judiciary, it will
appreciate
be
that the
available.
chairman has taken these
A recent
concerns into
GAO
account.
report, and I
Unlike the
apologize
original
for
version,
the
this bill does not mandate that the Commerce
disturbance
Department
behind me.
automatically adjust anti-dumping
I'm a
and
soft
countervailing duty
talker,
calculations
and
to account for China's currency policy.
yeah, I got
This
some
version
competition.
allows Commerce to consider many factors in determining whether or not China's currency policy satisfies
We've
the
got
definition of an export
the
subsidy,
proceedings
as it does
going on
today, and does not
in the
prejudge
House,
an
which of
outcome.
course are very
While I remain
important.
deeply concerned about
And,
using the countervailing
but
duty
we've
law
got some
to address
important
China's currency policy,
concerns
I believe the
today
bill
about
before us
justice. There we go. So now they took me off the air. I guess you get what you ask for. All right, the integrity of our judicial system relies on the promise of access to justice for all Americans. A central tenet of that promise is that the public must have trust that whenever they need access to the judiciary, it will be available. A recent GAO report on courthouse space found over 3.56 million square feet of excess space in recent courthouse construction, which has led some to conclude that less funding should be allocated to courthouses. Others have argued that the GAO methodology and resulting recommendations are seriously flawed. However, today's hearing is not about the GAO report itself, a matter that I have discussed at length in other forums. Instead, this hearing is about the threat to access to justice and the risk that the report will be used as justification to cut funding for critical pending courthouse construction, limit security for our judiciary, litigants, and the visiting public, or mandate courtroom sharing without consideration of the factors that go into how courthouses are used to deliver justice. Access to justice is an issue that has concerned me for many years. Through bills that I have introduced, including the Arbitration Fairness Act, and bills I have co-sponsored, such as the Open Access to Courts Act, I have consistently worked to open the courthouse doors. Congress, or to keep those doors open. Congress has a vital role to play in the process, and I look forward to working with all the members of this committee to address increasing access to our courts. The GAO report findings and the resulting calls to cut courthouse funding based on the report threaten the very nature of our constitutionally created three co-equal branches of government. I emphasize that the three branches are intended to be co-equal, separate branches. This balance of power is disrupted when the legislative branch intrudes on how the judicial branch conducts its business, such as by dictating how much courtroom sharing there should be or how to calculate the number of judges needed to meet caseload demands. My concern on this matter is well established. Yesterday, I sent a letter to President Obama asking him to continue funding courthouse construction projects without regard to the flawed GAO report findings. I am entering a copy of this letter into the record. I urge the Judiciary Committee to also strongly weigh in at this juncture. While the GAO report applies a strict formulaic calculation to courthouse space, the Judicial Conference and members of this committee know that the use of courthouses is not merely about numbers. As a former magistrate judge, I am very cognizant of the many other factors that go into how courthouse space functions, including the security needs and impact on the delivery of justice that no numeric calculation can adequately capture. In light of the concerns raised by the GAO report that I have just detailed, I want to announce today that I am planning to visit several courthouses next month in order to assess for myself, the state of courthouses that the judiciary believes to be in desperate need of funding, as well as a courthouse that has been recently built according to the judiciary's stated needs. I understand that Representative Eleanor Holmes Norton is very interested in courthouse funding as well and plan to work closely with her on this issue. I invite Representative Eleanor Holmes Norton and my colleagues on this subcommittee and the Transportation and Infrastructure Subcommittee on Economic Development, Public Buildings, and Emergency Management to join me in this trip so we can fully appreciate and have a fruitful discussion on the needs of the judiciary, as well as why I believe the Judicial Conference so badly needs funding for continued courthouse construction. I now recognize my colleague, Mr. Coble, the distinguished ranking member of the subcommittee, for his opening remarks. Thank you.
Thank you, Mr. Chairman. Appreciate your calling this hearing today. Good to have our colleague from Tennessee with us as well. During my inaugural run for Congress, Mr. Chairman, I held a press conference to announce my intentions, and a reporter in attendance asked why I was doing this. There was a straightforward question, so I chose a straightforward answer. I said I wanted to bring a sharp pencil to the Congress, and what I meant was I intended to pursue a policy agenda premised on less spending and lower taxes. Like it or not, that's still my philosophy. Sometimes it's worked out as intended, sometimes it did not. But today's hearing, Mr. Chairman, compels us to examine the role of government in our lives and how much we're willing to pay for the services it provides. Our focus is on the judiciary, a critical component of our government. Without the rule of law and an independent judiciary to administer it, the biggest and meanest just get their way, but that's not the American way. Because we are a civil society that values settling differences peaceably, providing adequate resources for the federal courts should represent a policy priority for Congress and the American people as well. But no one, Mr. Chairman, gets the proverbial blank check. And this is where we may need to break out the sharp pencils. The Government Accountability Office released a study, I think it was about 4 months ago, that suggests that our national courthouse construction program is fraught with waste. GAO alleges that the Government Services Administration has not exercised appropriate oversight in administering the program for much of the past 10 years. GAO furthermore believes the federal judiciary has contributed to these problems in 2 key respects. First, by not maintaining caseload protection records that help in measuring future workloads and the need for new judges. And second, by failing to adopt more expansive courtroom sharing policies. The results, if accurate, are alarmingly stark. GAO asserts that we've overbuilt federal courthouses by more than 3 million square feet. This equates to $835 million in unnecessary space, with an additional cost of $51 million to rent, operate, and maintain the space. The GAO study has generated buzz, to put it mildly, but its methodologies and findings have been questioned by others, including some of the witnesses who will testify today. To illustrate, the Administrative Office of the U.S. Courts correctly notes, in my opinion, that it is difficult to predict the judiciary's courthouse needs when the size of the judiciary is a function of congressional action or inaction. How accurate can such predictions be if Congress creates new judgeships piecemeal, as it has for the past, I'd say, two decades? I'm especially taken with the judiciary's robust defense of its role in our civic life. They emphasize that it's inappropriate for GAO to judge them by applying new standards, such as courthouse sharing strategies after the fact. The judiciary also maintains that the whole point of our courts is to dispense justice as expeditiously and as fairly as possible. How does a one-size-fits-all courtroom sharing plan further justice? How does it promote the quick resolution of legal disputes? Are the federal judicial events knowable and therefore predictable or not? So, Mr. Chairman, before we break out the sharp pencils, we need to delve into the facts and answer these and other questions. I don't want to promote the wasteful spending of tax revenue, but neither do I want to embrace a penny-wise and pound-foolish approach to providing our federal courts with the resources they need to do their respective jobs. I look forward to participating in today's hearing, Mr. Chairman, and I thank you and I thank the witnesses for their attendance and yield back.
I thank the gentleman for his statement. Without objection, other members' opening statements will be included in the record. I'm now pleased to introduce the first panel witness for today's hearing. Our first panel will be Representative Jim Cooper. Representative Cooper has represented Tennessee's 5th Congressional District since 2003 and is chair of the Congressional Courthouse Coalition Caucus, of which, in full disclosure, I'm a member. Representative Cooper sits on the Armed Services Committee and the Committee on Oversight and Government Reform. He is also an adjunct professor at the Owen School of Management at Vanderbilt University. Welcome, Representative Cooper. And Representative Cooper, please begin your testimony.
Thank you, Mr. Chairman. Thank you to Ranking Member Coble, Mr. Gonzalez. I appreciate this opportunity to testify before your subcommittee. It's a very important topic to get the prioritization of federal courthouses right, and I appreciate your interest in this important matter. The reason we formed the Courthouse Caucus, my friend Joe Bonner, a Republican from Alabama, and we're very grateful, Mr. Chairman, that you have joined the caucus. We wanted to get congressional support behind an objective, fair way of building new courthouses in America, instead of what is sometimes characterized as the old-fashioned pork barrel process of just those who have the most political clout grabbing the federal dollars and building whatever they want to build. I think that the federal judiciary has done a responsible job of trying to identify their needs and to have a rational plan for moving forward to construct new buildings. So the Courthouse Caucus is devoted to that task. We have 16 members, and in this last budget cycle, we succeeded in getting the top 5 priority courthouses on the list for construction, which was something of a novelty in this body. Things like that shouldn't be news, but it's nice when the federal judiciary's needs are actually identified and responded to by this co-equal branch of government. I have a selfish interest in this. I represent the Nashville area, and we have been identified as a needy courthouse area since the early 1990s. Current occupants of that building, not only the federal judiciary, but also other federal agencies, have had to put up with leaky windows and poor heating and air conditioning. And worse than that, security issues that include unreasonable delays in trials and unreasonable causes for new trials. Because, for example, when we're unable to get defendants into the courtroom outside the view of jurors, and the jurors see the defendant shackled, manacled, that can prejudice the jury and cause a demand for new trials. So it's very important that we have adequate facilities so that the rights of all parties can be protected, whether it's the prosecution or the plaintiff or the defendant. And to have a building in which jurors are notified that they have to wear overcoats because it's going to be so cold inside the building, or so hot on a summer day that you have to put in box fans, these are conditions that really are beneath the dignity of the federal judiciary. I think that the system of American law is the best in the world, and we need buildings that demonstrate the strength and stability of that system. We in Nashville are not greedy. We've waited now 15, 20 years to have our chance. We understand, according to some lists, we're now number 2 on the list. Other lists put us at number 6. We're patient folks. We just want the decision to be made, whether it's for Nashville or anywhere else in America, on the merits, objectively, using real criteria for caseloads and other needs of the federal judiciary. So I'm very grateful for your interest in this area. I would ask that my statement as written be put into the record, and I would be happy to help you and to dedicate the resources of the Courthouse Caucus to help the efforts of this committee, because this is a very important thing that we get right, and get right soon, because we all are aware of the need for jobs in our country. Building courthouses that are genuinely needed is the best way to help produce some of those jobs. So thank you, Mr. Chairman, for your interest in this important topic.
Thank you, Representative Cooper, for your work towards making sure that justice is not delayed so as to deny justice. Justice delayed is justice denied. And justice that comes under the conditions that you just spoke of I have to apologize for those conditions being in existence for the last 20 years, and I'm not even responsible. But that's sobering to hear of those kinds of conditions. And now,
Mr. Chairman, we would like to invite you to Nashville. You mentioned you would be visiting some federal courthouses, but you have a welcome, strong welcome in our community if you'd like to see firsthand the conditions in our current courthouse.
I'm going to take you up on that, and my wife will be happy to hear that. She is from Nashville, and that'll cause us to have to leave a day early to get up there, or stay a day later, either one. So we'll do that. Thank you.
Mr. Cooper, can we go to the Opry while we're there?
Whatever you would like. You're both my good friends. We're going to invite Mr. Gonzalez, too. We'll have the whole subcommittee come down, because we want you to see firsthand the real conditions on the ground, because that's the best way to make policy.
Thank you, Representative Cooper. And now we will begin our second panel. And Representative Cooper, let it not be said that you are not one of those very powerful members of Congress. We know better than that. So thank you for waiting your turn in line instead of Bogarting. Good afternoon, everyone. Our first witness on the second panel will be Mr. Mark Goldstein. Mr. Goldstein is the Director of Physical Infrastructure Issues for the Government Accountability Office. He is responsible for GAO's work in the areas of government, property, and telecommunications. Mr. Goldstein has held other public sector positions, serving as Deputy Executive Director and Chief of Staff to the District of Columbia Financial Control Board, and as a senior staff member of the United States Senate Committee on Governmental Affairs. Prior to government service, Mr. Goldstein was an investigative journalist and author. We welcome him here today. Our second witness will be the Honorable Michael Ponsa. Judge Ponsa is a United States District Judge for the District of Massachusetts and Chairman of the Judicial Conference Committee on Space and Facilities. Judge Ponsa was nominated by President Clinton in 1993, and prior to that was a United States Magistrate Judge for the District of Massachusetts. We welcome him here today. Our next witness will be Commissioner Robert Peck. Commissioner Peck has served as the Commissioner of the Public Buildings for the United States General Services Administration since 2009. He is responsible for the design, construction, and building management for 362 million square feet of government-owned and leased space. Prior to serving in this position, he worked at the Office of Management and Budget, the National Endowment for the Arts, and the Federal Communications Commission. Commissioner Peck also served as an associate counsel to the Senate Committee on Environment and Public Works, and was Chief of Staff to the late U.S. Senator Daniel Patrick Moynihan. Welcome, Commissioner Peck. Fourth witness will be the Honorable Robert J. Conrad. Judge Conrad is a U.S. District Judge for the Western District of North Carolina. Judge Conrad served as a federal prosecutor for over a decade and gained national attention when he was named Chief of the U.S. Department of Justice Campaign Financing Task Force in 2000. Prior to becoming a federal judge, Judge Conrad served as a U.S. Attorney for the Western District of North Carolina. We welcome Judge Conrad to our panel today. And our final witness will be Professor Judith Resnick. Professor Resnick is the Arthur Lyman Professor of Law at Yale Law School, where she teaches about federalism, procedure, feminism, and local and global interventions to diminish inequalities and subordination. Professor Resnick is the author of many articles on federalism and the federal courts, and recently argued before the Supreme Court. She is the founding director of Yale's Arthur Lyman Public Interest Program and Fund. In 2008, she received the Fellows of the American Bar Foundation Outstanding Scholar of the Year Award, and we welcome her here today. Thank all of you for your willingness to participate in today's hearing, and without objection, your written statements will be placed into the record, and we would ask that you limit your oral remarks to 5 minutes. You will note that we have a lighting system that starts with a green light. At 4 minutes, it turns to yellow, then to red at 5. After each witness has presented his or her testimony, subcommittee members will be permitted to ask questions subject to the 5-minute limit. Mr. Goldstein, please proceed.
Thank you, Mr. Chairman and members of the subcommittee. Thank you for inviting us here today to discuss the results of our report on the federal courthouse construction program, which we issued June 21st, 2010. Since the early 1990s, GSA and the judiciary have undertaken a multi-billion-dollar courthouse construction initiative that has resulted in 66 new courthouses or annexes, with 29 additional projects in various stages of development. However, rising costs and other federal budget priorities threaten to stall this initiative. This testimony, based on our report, discusses for 33 federal courthouses completed since 2000, 1, whether the courthouses contain extra space and any costs related to that space, 2, how the actual sizes of the courthouses compare with congressionally authorized sizes, 3, how courthouse space, based on the judiciary's 10-year estimates of the number of judges, compares with the actual number of judges, and 4, whether the level of courtroom sharing supported by data from the judiciary's 2008 study of district courtroom sharing could have changed the amount of space needed in these courthouses. In general, our findings are as follows. 32 of the 33 federal courthouses completed since 2000 include extra square feet of space, totaling 3.56 million square feet overall. This space represents about 9 average-sized courthouses. The estimated cost to construct this extra space, when adjusted to 2010 dollars, is $835 million. And the annual cost to rent, operate, and maintain it is $51 million. The extra space and its causes are: first, 1.7 million square feet caused by construction in excess of congressional authorization, 887,000 square feet caused by the judiciary overestimating the number of judges the courthouses would have in 10 years, and 3, 946,000 square feet caused by district and magistrate judges not sharing courtrooms. In addition to higher construction costs, the extra square footage in these 32 courthouses results in higher annual operating and maintenance costs, which are largely passed on to the judiciary and others as rent. Based on our analysis of the judiciary's rent payments to GSA for these courthouses at fiscal year 2009 rental rates, the extra courtrooms and other judiciary space increased the annual rent payments by $40 million. In addition, our analysis estimates that the extra space costs about $11 million in fiscal year 2009 to operate and maintain. I should note that GSA cited concerns with our methodology. Our methodology applied GSA's policies and data directly from original documents and sources, and our cost estimation methodology balanced higher and lower cost construction spaces to create a conservative estimate of the costs associated with the extra space. We believe that our findings are presented in a fair and accurate way and illustrate how past problems with the courthouse program could affect future courthouse programs and projects. Our second major finding was that of the 33 courthouses built since 2008, 28 have reached or passed their 10-year planning period, and 23 of those 28 courthouses have fewer judges than estimated. For these 28 courthouses, the judiciary has 119, or approximately 26% fewer judges than the 461 it estimated it would have, resulting in approximately 887,000 extra square feet. The extra square feet includes courtroom and chamber suites, as well as a proportional allocation of additional public mechanical spaces and sometimes secure inside parking spaces in new courthouses. Our third major finding indicates that courtroom sharing could have reduced the number of courtrooms needed in 27 of 33 district courthouses built since 2000 by a total of 126 courtrooms. about 40% of the total number of district and magistrate courtrooms constructed since 2000. In total, not building these courtrooms, as well as their associated support, building, common, and other spaces would have reduced construction by approximately 940,006 square feet. According to the judiciary's data, courtrooms are used for case-related proceedings only a quarter of the available time or less on average. Using the judiciary's data, we applied general accepted modeling techniques to develop a computer model for sharing courtrooms. The model ensures sufficient courtroom time for all case-related activities, all time allotted to non-case-related activities, such as preparation time, ceremonies, and educational purposes, and all events canceled or postponed within a week of the event. The model shows the following courtroom sharing possibilities. 3 district judges could share 2 courtrooms, 3 senior judges could share 1 courtroom, and 2 magistrate judges could share 1 courtroom with time to spare. During our interviews and convening of an expert panel on courtroom sharing, some judges remained skeptical of sharing and raised potential challenges to courtroom sharing, but other judges with sharing experience said they have overcome those challenges when necessary without postponing any trials. The primary concern judges cited was the possibility that all courtrooms could be in use by other judges and a courtroom might not be available. To address this concern, we programmed the model to provide more courtroom time than necessary to conduct court business. In our report, we recommended that the administrative GSA take the following 3 actions. 1, establish sufficient internal control activities to ensure that regional GSA officials understand and follow GSA space measurement policies. 2, to avoid requesting insufficient space for courtrooms based on the any court model, to establish a process in cooperation with the AOUSC by which the planning for the space needed per courtroom takes into account GSA space measurement policies. 3, report to congressional authorizing committees when the design of a courthouse exceeds the authorized size by more than 10%. We also recommended that the AOUSC, on behalf of the Judicial Conference, take the following 3 actions. Retain caseload projections for at least 10 years for use in analyzing the accuracy and incorporating additional factors into the judiciary's 10-year judge estimates. 2, expand nationwide courtroom sharing policies to more fully reflect the actual scheduling and use of district courtrooms. And 3, to distribute information to judges on positive practices that judges have used to overcome challenges to courtroom sharing. This concludes my testimony, sir. I am pleased to answer any questions that you or other members of the subcommittee may have. Thank you.
Thank you, sir, for your testimony. Judge Ponser, please proceed.
Thank you. My name is Michael Ponser. I'm the United States District Court Judge for the District of Massachusetts Western Division. I've been a District Court Judge for 17 years and a Magistrate Judge for 10 years before that. I want to thank you, Mr. Chairman, Ranking Member Coble, and other members of the committee for having us here today to speak about these very important issues. I also want to note that my colleague, Judge Conrad, from the Western District of North Carolina, will be picking up on some of the themes I will touch on. I also want to thank particularly Congressman Jim Cooper for coming here today and in his written comments and oral comments articulating so eloquently the concerns that I will also try to address here today. My message to this committee is very simple. We need assistance from your subcommittee in facing what I think is a very grave situation which threatens the shutdown of the national federal courthouse construction projects. This shutdown will threaten access to justice for millions of Americans, compromise judicial administration, jeopardize courtroom security, and waste potentially millions of dollars. Let me give you some background on these comments. On May 25th, as Mr. Goldstein indicates, we both appeared before the Subcommittee on Economic Development, Public Buildings, Emergency Management to discuss the GAO report. We had a vigorous debate about that, and I am pleased that the committee members are aware of our differences with the GAO report. I consider the report to be largely nonsense, and the 3 justifications supporting the supposed waste of public money to be very disturbing, unfair, and untrue. I don't want to get into all the reasons why I think that report went so far astray, because I want to use my time for something more important, but I'm happy to address in detail any questions you may have about that. One point I will make is that although we considered the GAO report to be terribly unfounded, poorly done, and deeply unfair, we agreed with all of the concrete recommendations that were made in the GAO report. We agreed that we had either already implemented them or would implement them, with one possible exception, which I may touch on now. The GAO report discussed the possibility of courtroom sharing and came up with models for courtroom sharing that frankly had not only me, but the entire federal judiciary aghast. The notion, as they suggested, that 3 active district court judges carrying caseloads of 400 to 500 civil cases, 100 to 200 criminal cases, 3 active district court judges could share 2 courtrooms and provide the sort of justice that Americans expect and deserve was shocking. We asked for their backup, their modeling for this, and we waited 4 months to get it. They repeatedly said that they used our data. Well, we knew what our data was. What we wanted to know was, how did they cook it? And we did on September 17th, finally get a copy of the report from their modeling person. The man who was responsible for handling their modeling is a gentleman named Mr. Higgins, who's a lovely man. He has a BS in electrical engineering, and his background includes modeling consumer soap production, construction of John Deere tractors, and the extraction of nickel from granite ore. The particular group that they had run the modeling had virtually no experience in court-type procedures. They knew about conveyor belts, robotics, tractors, and various other things. These were the people that they trusted to develop these models for courtroom sharing, to tinker with the heart of the American constitutional system, and to come up with this notion that 2 courtrooms were sufficient for 3 active district court judges, 6 for 9, 9 for 12, and to blame us by retroactively applying this supposed policy and accuse us of overbuilding 946,000 square feet of courtroom space since 2000 because we did not adopt this ridiculous notion of courtroom sharing. We looked into it further, and let me tell you how they went about deciding that we could have 2 courtrooms for every 3 district court judges. They simply took the 10-hour day. They said that federal courts are in session from 8 a.m. in the morning till 6 p.m. That's right in their report. 10 hours a day, the average district court judge is in court for 6 hours. So multiply 6 times 3, that's 3 judges, you get 18, 2 courtrooms, 10 plus 10 equals 20, 18 goes into 20, therefore 3 district court judges can use 2 courtrooms. No consideration of continuances, no consideration of emergencies, no consideration of issues such as border states. This is how they came up with their courtroom sharing model. Since then, things have gotten to be even more grave because, as you know, there was a letter that went out on August 2nd from the Subcommittee on Economic Development, Public Buildings, and Emergency Management saying that we should shut down the entire federal courthouse program nationally until we engage in the sort of robust courtroom sharing that was, frankly, absurdly suggested in the GAO report. The impact would be devastating. This is the judiciary's 5-year plan. These are courthouses that have all been waiting at least 10 years. There is no debate that every single one of those courthouses is desperately needed. We're talking about Los Angeles, Mobile, Nashville, Savannah, San Jose, San Antonio, Charlotte, Greenville, Harrisburg, Norfolk, Virginia, Anniston, Alabama, Toledo, Ohio, Greenbelt, Maryland. Every single one of those communities is waiting for a courthouse, and now we are faced with a suggestion that we should stop everything and keep these communities from getting the judicial resources that they need. Hold up this plan, shut everything down, make people wait. This has an insidious effect on litigants. Imagine you've suffered a violation of your civil rights. You've suffered some affront to yourself. Are you going to ask yourself, can I go into court? Will I have to wait? Will I get a firm trial date? You're an assistant U.S. attorney deciding whether to initiate prosecutions. Will you have the resources to bring them? Security is threatened. Just a few months ago, we had an incident in Las Vegas. It happened to be a courthouse that was secure, and a very courageous court security officer died defending that courthouse. If that courthouse had not had an atrium and proper security, we would have had many more people dying. Money is being wasted. Right now, we have a courthouse in Salt Lake City. The money has been appropriated. They're not even on our 5-year list. We're ready to go with that courthouse plan. Because of downturn in the economy, we can save $25 million if we begin that courthouse project now. The money is not being appropriated. We're losing that opportunity to save funds. We ask, we'll end where I started. We ask that we do not allow these types of bricks and mortar issues to absorb and digest important values in our constitutional system, and we would appreciate any help this subcommittee can give us. Be happy to answer questions.
Thank you, Judge Ponser. Next, Commissioner Peck, please begin.
Thank you, Mr. Chairman, Ranking Member Coble, and Representative Gonzalez. I am Robert A. Peck. I am Commissioner of the GSA Public Building Service. As you noted, Mr. Chairman, we own or lease 360-some million square feet of space in communities all across this country, and we provide space for more than 100 federal agencies, law enforcement agencies, the military, the social service agencies that help our citizens, and we're prouder of none of them than the judiciary and our role in providing space for them. Federal courts play a critical role in the constitutional framework of our democracy. We are proud that for the past 15 years in particular, we have been building courthouses worthy of that role, worthy of the American people, and worthy of the communities in which our courthouses are built. Courthouses are traditional landmarks dating back way before the founding of our country. They have in our country, however, whether state, local, or federal, often been the center of gathering and the symbols of our democracy. The federal courthouses, in particular, must support the federal judiciary's mission of ensuring fair and impartial administration of justice for all Americans while providing security for judges, jurors, and others engaged in the judicial process. This makes for complicated buildings and, yes, higher costs than the ordinary commercial office building. GSA has developed a strong partnership with the federal judiciary. Since we began our Design Excellence program and Congress began funding a nationwide program of courthouse renovation and construction, we have compiled a solid track record of delivering high-quality buildings that support the court's unique needs while enhancing the building's surroundings. We do so within carefully considered design and budgetary guidelines and pursuant to congressional authorization and appropriations. Thank you for having this hearing today and focusing on the importance of these buildings and the effective administration of justice. We support the judiciary in carrying out this mission by constructing courthouses that allow them expeditiously and impartially to adjudicate cases for the American people. The courthouses that we construct are economic, given their mission, sound, and prestigious. We work with the federal judiciary to develop requirements to meet their needs. Since 1996, as Judge Ponser alluded to, the judiciary has used a 5-year plan to set priorities on new courthouse construction projects, and we have followed it as best we can. We use the plan to develop project requirements in size and in cost that meet the needs of the courts. These requirements result in requests to Congress for authorization and appropriations. Since the program's inception, 67 new courthouses or annexes have been constructed, and Congress has authorized and appropriated approximately $7.5 billion for this program. We are continuing to improve our work on this program. In particular, we are improving the energy efficiency and resource use of the courthouses that we are building. We have established multiple layers of management and controls to make sure that the costs of our courthouses are within guidelines. We stay within the statutory threshold of 10% of appropriated and authorized funding levels, or we notify Congress accordingly. We have maintained the space requirements that we have presented to the Congress to the best of our ability. We have agreed in line with the GAO report that we will notify the Congress when space exceeds 10% of the amount that we initially reported to Congress. And I want to be clear, sometimes there is a difference in the space that we initially provide to Congress as an estimate of courthouse needs, because as design becomes more detailed and we get closer to the point where we can construct and we have an actual site, which we often don't have when we first report to you, when we have an actual site, we can then tell exactly how much the space is going to be. We are, in fact, reporting to Congress any deviation in that size, whether it's 10% or not. We just want to err on the side of total transparency. We give the courts a lot of credit for the fact that they have, over the years, agreed to share courtrooms among certain judges, senior judges, and magistrates, and that has allowed us to build slightly smaller buildings. We have made important strides in improving the courthouse program, and we believe that the GAO report ignores the strides we have made. And I won't repeat what Judge Ponser said, other to say, if I can characterize it. The GAO report exhibits breathtaking ignorance of basic construction methods and construction cost methodologies, leading to ludicrous conclusions. And for an agency that was founded in accounting, I can tell you that basically they have double counted in figuring out how much the so-called empty space in our buildings contains. Our concerns with the report, to be more specific, are GAO used a space measure that assumes that upper space in building atriums is included in the gross square footage of an asset. That is simply not true. And no matter what measuring standard you use, take a look at this room. It has a certain volume. It only has one floor. We count the square footage of the floor. GAO compounded this erroneous assumption by ascribing inflated operating and construction costs to the empty volumes and retroactively applied a methodology of, quote, courtroom sharing, unquote, to buildings designed in some cases more than a decade ago and predating the inclusion of courtroom sharing in the design guide. Most egregiously, the GAO report could be read to assert that GSA has neglected willfully congressional direction in the courthouse program. It's categorically not true. We have sought and followed regular authorizations and appropriations and reported regularly to the Congress on our program. We are always happy to consult with anyone on doing better in running this program, but we are proud of what we have done to date, and will hopefully be able to work with you and the Transportation and Infrastructure Committee in making this program even better. Thank you very much.
Thank you, sir. Judge Conrad, please. And yeah, your microphone, and pull it closer.
I speak to you with 5 years of experience as a federal district court judge, Western District of North Carolina, located in Charlotte, as well as 15 years of previous experience as an assistant U.S. attorney and as a U.S. attorney. 20 years combined practice in the federal court in Charlotte, North Carolina. And I come to you today not to whine, but to inform you about what it's like in the field in our federal court. We, like the court in Nashville, Tennessee, which Congressman Cooper addressed, are on the 5-year plan. We have been on the plan for nearly 20 years. I'm the third chief judge in our district during the time period that we've been on the 5-year plan. My predecessor, Chief Judge, ruefully comments on that posture as being in the 12th year of a 3-year design program. We have patiently waited in line, but the line never moves. And the lack of movement in the line affects the delivery of justice in the Western District of North Carolina in significant ways. And I'm going to speak about 3 of those ways. The issue of courtroom sharing, the issue of court security, and the issue of the deteriorating conditions in our building. I believe that Congressman Coble knows that our courthouse is located is an old historic building built in 1915, renovated in the 30s, and it contains only 2 courtrooms for a city the size of Charlotte, with a very complex civil docket and a very aggressive U.S. Attorney's Office. We have applied the concept of courtroom sharing. We have more judges than courtrooms in Charlotte. And I want to tell you about our experience. Courtroom sharing is an art, not a science. Our district court judges try to schedule around each other so that we don't intrude on each other's work. And one of the ways we've attempted to do that, we have more judges in courtrooms, and so we have on occasion commandeered our magistrate judges' courtroom. Chairman Johnson, you spoke about your past as a magistrate judge. One of our magistrate judge courtrooms has a jury box, but the design of that courtroom is such, it's an L-shaped design. It's a very small courtroom. It was not designed for district court work, but out of necessity in an attempt to handle our docket, we sometimes use that courtroom. Some of the attorneys cannot see all of the members of the jury. The jury has a hard time seeing the witness box on the other side of the courtroom. The witness box in this courtroom is several feet from the trial bench, which is not that elevated. It's 5 feet from the defense table, and it's inches away from an exit door. It is woefully inadequate. The security concerns coming out of that situation are obvious. Many of the criminal cases that we pursue involve cooperating witnesses hoping to get a reduction in sentence as a result of their cooperation. They are testifying against defendants seated just feet away from them. I don't think this is the model of the Confrontation Clause our founders anticipated. It's a security concern. We have trouble when we have had to handle civil cases in that courtroom as well. We've had civil cases involving numerous attorneys, out-of-state attorneys, and trying to pack them into a very small courtroom has created difficulties in our administration of justice. Another way in which we have tried to share space in a way that accomplishes justice is that we schedule our courtroom usage, and within the last couple of years, I had a situation where I had the courtroom for a week, and another judge was scheduled to try a jury trial the next week. And so what I tried to accomplish was to try 2 criminal trials in a 1-week period of time. The first trial involved about 7 robberies and a shooting involving injuries. It was a complex case. We kept the jury till 6 o'clock every night, dealt with trial motions both after the jury left for the night and the morning before trial. But nonetheless, that trial took longer than expected. In order to handle my docket, on the 4th day of trial, we instructed the jury, and then I gathered the court reporter, the marshals, the probation officers, and we walked down the hall to the second courtroom that I previously spoke about, the L-shaped courtroom that is so problematic. And we began a second trial, an armed drug deal transaction, and started selecting a jury and putting on the evidence in that trial, while the jury was deliberating in the first trial. And the jury in the first trial had a series of questions. In order to answer their questions, I had to march back down the hall into the first courtroom with all the assembled staff. The marshals had to escort the defendant from trial number 2 downstairs to a holding cell and bring the first 2 defendants up. We answered the question, and the marshals had to reverse the process, bring 2 defendants in custody down an elevator to a holding cell, pick up the defendant for the second trial, and escort him to that trial. All in order to get our work done, in order for a second judge to start a trial the following Monday. That is extremely problematic for us. We exhausted our court reporter. The marshals were strained to capacity. While we were going back and forth, 2 different juries had to waste time waiting for us to resolve business in the other court, and victims and their family members, defendants and their family members, were all convenienced, not to mention the stress it put on the trial court attempting to administer justice in both those situations. That's been my experience anecdotally. My colleagues have reported similar concerns. We sometimes double book the courtroom, anticipating that many trials will resolve without trial. When that hasn't happened, on at least one occasion, we've had to find court space in a state county courthouse and try a case there. My conclusion from all of this is that we've tried courtroom sharing, and it doesn't work. I want to speak about security concerns. In our old historic building, we share everything. And I'm not saying that in a positive light. The restrooms are shared. Our courthouse staff, the public, members of defendant families, victims, agents, lawyers, even grand jurors, even newspaper reporters all share the same restroom space. We share an elevator. There's one elevator in our building used to transport incarcerated prisoners and witnesses. Our staff uses that elevator as well. Now, the only reason a defendant is in custody is either the judge has just sentenced that defendant to a time in prison, or another judge has found that that person is a flight risk or a danger to the community. Nonetheless, those who have been found to be such regularly use the same elevator as our courthouse staff. Our corridors are probably our worst security concern. When people leave our courtroom at the end of a trial or a hearing, they go into a corridor that contains chambers, clerk's office, and other court personnel. Oftentimes, after a sentencing hearing, emotions run high, but agents, lawyers, members of defendant families all exit in the same way at the same time. And there have been numerous occasions where marshals have had to break up verbal arguments between competing parties. I want to mention an experience I had as a sentencing judge in which I sentenced a gang member to a mandatory minimum sentence. And as I exit our courtroom, my exit is within feet of the door through which the marshals escort incarcerated defendants to the elevator for transport down to the holding cell. It is not uncommon for me to be exiting the courtroom about the same time as a criminal defendant. And in this one situation, after I had just sentenced a defendant, we both got into the hallway together, walked side by side, and I was glad that I reached the end of the hall and turned left as the defendant asked the marshal how much of that 20 years he was going to have to serve. And I was glad that I got to the turning point before the marshal told him that there's no parole in the federal system. That kind of situation where judges who have to sentence people or conduct other very serious business and then have to share quarter space, elevators, and other public facilities is untenable. We have a sally port in our old building where the defendants are brought in from local custody. It's open to public view, and the sally port is within a couple parking spaces of where the judges park their vehicles. All of this to say that we've been on a list for a number of years. We have serious security concerns, and they're impacted by the failure to get the appropriate funding. And then as time has passed, our very historic building has deteriorated. And this is not a criticism of GSA. They've been very responsive to us. But years ago, thinking we were going to build a federal courthouse, we swapped our courthouse with the city of Charlotte for prime uptown real estate. We thought we would be constructing a courthouse soon. They thought they could use our existing courthouse for a law school. But we are still in our building. Our land is an uptown parking lot, and we pay rent to the city of Charlotte to be in our building because we haven't been able to construct our new courthouse. Not much incentive on GSA's part to pour money into an old building when you don't own it and you expect to move from it soon. And our old courthouse was never built with modern security concerns, with 21st century technology development in mind. It's antiquated, it's deteriorating. At one particular sentencing hearing, the roof literally fell in on the defendant. There was a piece of ceiling tile that fell on the defendant's table as I was conducting the sentencing hearing. We have buckets strategically placed in our courtroom to catch the rain falling from the leaky roofs. I use a Mac Air laptop when I'm in court. To my right is a computer monitor that allows me to get live transcripts. But beyond this technological facade are problems that we deal with in a very archaic way. Within 5 feet of my bench, we have buckets that catch the rain that leaks through the roof when we have a storm. And Mondays are interesting after a rainy weekend in our courtroom. My conclusion is this. I serve on the Judiciary Committee's Space and Facility Committee, Subcommittee. And I have learned that Charlotte is not unique. Everyone on our 5-year plan has been there for a decade or more. Our tripartite form of government requires that before justice is done in the federal criminal arena, the executive branch has to prosecute and the legislative branch has to appropriate. As your co-equal branch, we ask you to fund the construction of badly needed courthouses and to do so in a manner that permits maximum flexibility to our use of and access to courtrooms.
Thank
Thank you.
you, Judge Conrad. I believe your 5 minutes has expired. Next, we will hear from Professor Resnick.
Thank you, Mr. Chairman, Ranking Member, members of the committee. My name is Judith Resnick, and I'm the Arthur Lyman Professor of Law at Yale Law School. I'm very honored to participate in this hearing. I've been a guest at symposia convened by the GSA and by the GAO and by the Administrative Office, and I'm happy to have a chance to participate and comment here, and I want to make 3 points in these 5 minutes. First, in 1850, there was not a single federal building owned by the United States government that had the name U.S. Courthouse on the front door. There were fewer than 40 judges at the trial or lower levels around the United States, and there were about 50 federal government buildings, marine hospitals, and customs houses. Today, there are more than 550 buildings that include the name U.S. Courthouse. And why are there those new buildings? Because in a deep way, over the last 150 years, this country has been in the forefront of inventing adjudication as an important part of functioning democracies. We can take for granted the courts, but in some way the courts as we inhabit them are new in some respects. We've had independent judges for the last 250 years through our Constitution. Our Constitution and state constitutions guarantee rights, R-I-G-H-T, of access, public access to courts that have to be open, moving old rituals or rights, R-I-T-E-S, and spectacles of former governments into absolute obligations that we have a right to watch our government and our adjudicatory processes. Fairness as an independent idea of equal dignity among the litigants and between the court and the litigants is a relatively new idea, and most startling of all of us who are in this room are now rights holders, and 100 years ago, we weren't rights holders in the same way. So we need to appreciate that we are the heirs to a new tradition. The buildings look big and stony, but they're actually the iconic emblem of a new commitment that this Congress has made to courts as central to American government. The Administrative Office tells us that between 1960 and 1990s, this Congress created more than 400 new causes of action for people to bring rights and claims and cases to courts. If you start in the beginning of the 20th century, there are about 30,000 filings. By the end of the 20th century, there are more than 300,000 filings. So when we reflect on this achievement, we have to understand these are important sites of democratic practice where we can call the government to account as well as debate with each other the rights and obligations we have. It was that optimism and expectation that led the Long-Range Planning Committee of the Judicial Conference in 1995 to say, by 2010, there'll be about 600,000 cases or more in the federal district courts. So that's the first proposition, is a little reflection. The second point is, if the project of the 20th century was to get us all into courts, the project of the 21st is what to do now that we're all there. And the problem is a real one. For some people, it's help equip us. We hear calls of civil Gideon. The chief judge of the state of New York has said we really need to provide rights of access and help people who need to enforce their civil rights to be able to come to court with lawyers. The Legal Services Corporation, the creating of more judgeships and more courthouses is a part of it. That's one package of solutions. But others have resolved that instead of that, they need to devolve or outsource our adjudication. So a vast amount of decision-making occurs in administrative agencies. The Social Security Administration has more filings in a year than the federal district courts, holding bankruptcy aside. The Veterans Administration, the Employment, Immigration. In 2001, there were more than 700,000 evidentiary hearings in those 4 federal agencies, as contrasted to a lower number in the federal district courts. And we're watching the privatization of adjudication. I brought my cell phone contract, like yours, is likely to say, mine certainly does say, I can't file a lawsuit in federal district court. I have to go to mandatory arbitration, and I'm not able to enforce my federal statutory rights in federal court or state courts because of these limitations. Further, the United States Supreme Court, so many times 5-4, has imposed new hurdles through pleading requirements, through summary judgment that limits jury trials, through new immunities, through limiting implied causes of action. There are lots of factors, but the end point is that instead of those 600,000 cases in the U.S. federal district courts, civil and criminal, we've roughly seen over the last decade that filings are relatively flat instead of rising, as had been expected. So the idea and concern about underutilization may exist, which gets me to my third and final point. The answer, if there's a finding of underutilization, is not to stop building courthouses or funding judgeships or confirming judges. The answer is to find a way to help those people get to court and enforce their rights. I know that the chairman has introduced the Arbitration Fairness Act in order to create a possibility for consumers and then employees to be able to bring their cases to court and not have adhesive contracts be enforced. Additionally, I hope that Congress will return to the Equal Access to Justice Act, which is the provisions that enable a victorious plaintiff against the U.S. government to recoup fees. The U.S. Supreme Court last spring interpreted that statute as providing that the fees go back to the claimant rather than the claimant's lawyer. And so a man who had won against the Social Security Administration and had about $4,000 in attorney's fees, instead of it going to his lawyer, because it went to him and the government had a claim against him, his lawyer didn't get his $4,000 fee. So there are many, looking at the Legal Services Corporations and equal access to justice, and as I suggested in my written statement, that there's a great disparity across the United States in terms of density of use. This Congress in 1990 created the Civil Justice Reform Act. It asked each district court to convene individual committees to look at how the civil justice process was going on. One could create such committees at the district court level to talk to the users, state court, federal court, lawyers, public and private users, to say how are we using this space and to find ways to populate the courts rather than to close down the process and limit access to them. So this is a very important topic about how to get people into courts, and I commend the chairman for initiating a conversation about the relationship between courthouse construction and literal access to courts. And I suggest that there are many ways to integrate the system and think about the state, federal, and administrative adjudicatory needs of the country and find ways to get us all able to use them. Thank you.
Thank you, Professor Resnick. I have a few questions, Mr. Goldstein, and if you would, I've got 4 questions that can be answered either yes or no. And if you could answer the 4 questions yes or no, then I'll give you time to explain if you desire to do so. Is that fair enough? All right, thank you. 1, did the GAO conclude that no new federal courthouse construction projects should be funded?
No, sir, that was not in our report.
All right. 2, did the GAO conclude that the recommended courtroom sharing must be applied?
We made no recommendation per se about courtroom sharing other than they should adopt their own policies.
3, did the GAO conclude that security concerns in courthouses should be subjugated to space calculations?
We did not directly address security concerns in this report, sir.
And 4, did the GAO conclude that the Judicial Conference has resisted a congressional directive to share courtrooms?
No, sir, we did not.
And I lied, I've got a 5th question. How much did we pay for that report on courtroom sharing,
You paid
the modeling?
You paid roughly $45,000.
Mm-hmm. Okay. All right, now any explanation that you would like to give with respect to either one of the 5 questions?
No, because I answered with more than a simple yes or no.
All right. Okay, thank you, sir.
Certainly.
Judge Ponsner, my next question, in fact, Judge Conrad, you may have something to relate on this question as well. I've extended an invitation to the United States Marshal Service, but they were not able to join us as a witness on your panel due to scheduling concerns. The Marshal's Service is planning to submit a written statement for the record, however, and maintaining security in our courthouses is extremely important, and I assume that this is a concern that's shared by all of the members on this committee and the public. The marshals play the key role in ensuring that security. Can you discuss the courthouse protections provided by the Marshal Service, and can you also discuss the increased need for those protections in light of recent violence in courthouses, including a shooting in Atlanta several years ago and the increased threat of terrorism since 2001? And also, can you discuss how that changes the funding requirements for the judiciary? Judge Posner.
Yes. The legendary Judge Arnold once said of the courts, there has to be a place where people can go and be safe, and we have to be it. There has to be a place where people can go and have their rights vindicated, and we have to be it. If we don't have that, we're Somalia, we're northern Mexico, we're Colombia. Our judicial system and the protection of people who seek access to our judicial system must be secure. And there is no question that that is getting to be more and more difficult. In my little town of Springfield, Massachusetts, which has about 150,000 people, before we built our new courthouse, I came into my court one day and I found bullet holes in the window facing the jury. Imagine the unnerving experience of sliding into a jury box and seeing it look like something out of Al Capone. Bang, 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 4 bullet holes in the window shot from an adjoining garage over the weekend. I was using, as with Judge Conrad, elevators that were used by the same defendants that I just sentenced. They were usually in custody, fortunately, but I would also take the elevator with their family members. And there were some pretty tense elevator rides with family members and fellow gang members of individuals that I had sentenced. Costs have gone up. New courthouses have got to be blast resistant. There has to be a certain amount, at least on the lower floors, of bullet-resistant glazing. Setback requirements have increased. Architects have come to learn how to construct bollards and other reasonably attractive devices which serve to keep vehicles away from the courthouses. We live in an environment where we have to expect the possibility of serious problems. In the Los Angeles courthouse, which is one of our highest priorities, if it's not our highest priority, they are trying Mexican gang cartel cases with sometimes a couple of dozen defendants at a time, and they have the courtrooms arranged in such a way that the defendants can be shackled while they're in the courtroom out of the view of the jury. This is not going to get easier. It's not going to get easier. And the construction of courthouses that can handle this is absolutely essential. So yes, Mr. Chairman, it is more expensive, it is pressing, but it is critically important if we are going to maintain civil society.
Thank you. Judge Conrad, anything to add to that?
Briefly, I think our marshals serve heroically, are asked to do a great deal with not sufficient resources. Our marshals in recent cases in Charlotte have dealt with gang cases and people in witness protection programs and trying to transport these defendants and witnesses in a way that doesn't prejudice them in front of the jury. And given the inadequate security the inadequately designed security measures in our courtroom and the amount of things we ask marshals to do in a very dangerous situation, I think they perform heroically, but the funding issue for them is always an issue.
Thank you. Professor Resnick, can you discuss increasing access to justice in, well, you've discussed increasing access to justice in both your written statement and your testimony. What steps should Congress take to increase access to the courts, and are there any particular initiatives that you would like to see?
I do have specific suggestions. First, to commend to you the legislation that you've initiated, which is that the Federal Arbitration Act, which was created in 1925, spoke to mandatory arbitration, spoke to changing the judicial view, which was very negative arbitration, in commercial activities. In 1925, it isn't clear that the U.S. Supreme Court would have interpreted the Commerce Clause as reaching the employment contracts of an individual and their employer, or a modest consumer contract. Up until the mid-'80s, the U.S. Supreme Court further interpreted the Federal Arbitration Act as not applying to contracts that we would call adhesive, that I don't have any negotiating capacity but have to sign off, and further interpreted some federal statutes as so important that they, of course, had to be in the public realm, and therefore the federal judges, like those sitting on this panel, needed to rule on claims of right. Starting in the mid-'80s, however, the Supreme Court reversed its interpretation, often 5-4, and said instead that the FAA, the Federal Arbitration Act, did apply to eventually employee, consumer, and a host of other contracts, that if you wanted to argue that the alternative did not, in the terms of order, adequately vindicate your statutory rights, you, the party protesting the contract, had to show that the other proceeding was too expensive or too difficult. I know.
If you would, go ahead and wrap up that question.
And so these are statutory interpretations that obviously dissenters on the court think are the wrong interpretations. Congress has the complete ability to insist on the interpretation of these statutes or to reenact amendments to these statutes that make plain that they should not be applied to consumers and employees. Congress has already done so for franchisors and franchisees in some car cases and in an Automobile Fairness Act in 2002. Congress can do this again. The Equal Access to Justice Act can be revisited to be sure that the lawyers, not the prevailing party, get the fees. And furthermore, you could pass a statute like the Civil Justice Reform Act called the Equal Access to Courts Act of 2010 that would invite all of us into a conversation about how to help get access to courts and put on the agenda civil Gideon, state courts and state court needs, turning to the State Justice Institute and asking for information from the Chief Justices of the state courts, as well as from functionally the judges who are working in administrative agencies, because what we want is public decision-making.
All right, thank you, Professor. And this question will require either yes, no, or just silence. Does anybody on the panel does anyone on the panel have knowledge of any case where the judicial branch, the co-equal judicial branch of the United States, has ordered the legislature to fund corrections to courthouses or judicial facilities that are uninhabitable. Has anyone ever heard of such a thing happening before? Okay, everyone is silent, so I suppose not. That'd be an interesting law school exam.
In the law school hat here, I should add that there are state courts where state judges have held that the failure to fund judiciaries violates state separations of power obligations. There's a pending lawsuit in New York because there's been a failure to raise judicial salaries. And in Canada, the Canadian Supreme Court held that there has to be independent setting of judges' salaries. So there are at least some models for courts saying to legislatures, please fund us as a matter of constitutional independence.
Thank you. I'll now turn it over to the ranking member of this subcommittee, Mr. Coble.
Thank you, Mr. Chairman. Good to have you all with us. The courtrooms and courthouses portrayed by Judge Conrad and Congressman Cooper are inexcusable. Conversely, I am confident there are some courthouses and courtrooms that are excessively lavish, and I think they would be equally inexcusable. Let me put the question to the two judges. Gentlemen, what can the judiciary do to fulfill its constitutional mission in a more cost-efficient manner? Judge Posner or Judge Conrad?
There are two initiatives that I would highlight, I think, at least to start the conversation that I can think of. The first is the asset management planning process that the judiciary has been adopting for the last several years. That was referred to by Congressman Cooper. It means that we are able to apply objective criteria to courthouse situations and only fund new courthouses or renovations to existing courthouses where, applying an objective yardstick, we find that it is really needed. And that process has been very helpful in prioritizing projects and making sure that only the projects that are needed get funded. That's one. Two, we have a design guide now, which has been refined over the recent years, and which ensures that we are able, to a very great extent, standardize courtroom sizes, ceiling heights, offices, square footage, in a way which keeps costs under control, despite the criticisms, and we aren't perfect, but despite the criticisms, we have improved that area of our effort tremendously. We were the first branch of the government to do really careful asset management planning, and we have specific criteria for that, and we are continuing to apply those criteria. The third point that I think I would emphasize is the fact that there is some requests that we courtroom share, and we have been courtroom sharing. We have taken that initiative, we have studied it, we took the step of now we have 2 senior judges sharing 1 courtroom in our new construction. That was a difficult process for us to come to. The senior judges are among the most revered, in some cases beloved, members of our cohort, and we did that. We are sharing with magistrate judge courtrooms now, 2 for 1, with an extra criminal courtroom set aside. That has allowed us to tighten up on our courtroom construction. We are studying sharing of bankruptcy judges, and we are thinking of sharing for larger courthouses.
Do you concur, Judge? One more question, if I may, Mr. Chairman. The GAO indicated that the judiciary may have contributed some of the problems by not maintaining a caseload protection record that help in measuring future workloads and the need for new judges, and secondly, by failing to adopt more expansive courtroom sharing policies. Judge Conrad, you want to respond to that? And I'll be glad to hear from Mr. Goldstein if he wants to answer it in rebuttal.
Could you repeat the question? I'm sorry.
Yeah, the GAO indicated that the judiciary may have contributed to the problems by not maintaining caseload protection records that assist in measuring future workloads and the need for new judges, A, and B, by failing to adopt more expansive courtroom sharing policies.
I think Judge Ponser's response to the courtroom sharing question, it responds to that.
Okay.
I think the magistrate judges, the bankruptcy judges, and the senior judges, we are engaged in a sharing policy, the active Article 3 judges, for the reasons I described in my testimony, I think that sharing would be counterproductive and contrary to the needs of justice.
Thank you, sir. Thank you, sir. Mr. Goldstein will respond.
Thank you, sir. The notion that we asked the courts to retain historical records comes from the fact that it's difficult for them to predict with any certainty, obviously in a number of ways, just how many judges, will be in any courtroom in 10 years. Everyone recognizes that between the, vacancies and being able to appoint judges, as well as when senior judges will actually change. The area where we do think they can do a little better is in understanding the connection between caseloads and the need for judges, because a number of the case studies, courthouses we went to, showed that despite their prediction that there would be a significant increase, and therefore they requested additional judges and built out space to accommodate that, there had been no change in caseloads. So by having a longer record, we would hope that they would be able to then better predict and better understand the varieties and and the kinds of things that go into making those numbers up.
Thank you all again. I yield back, Mr. Chairman.
Thank you, Ranking Member Coble. Next question from Congressman Gonzalez.
Thank you, Mr. Chairman, and I know that I'm going to have to be really brief, so I'll ask the witnesses to see how brief they can be in the responses, but I just want to touch on something, Mr. Goldstein. In the GAO report, and the problem for the rest of the witnesses, Mr. Peck already knows this, the commissioner knows this, we place great stock on the GAO because we charge them with so much in the way of responsibility, and we always say, let's get a GAO report on this thing, so that's why we are where we are today. However, Mr. Goldstein, do you have an opinion as to whether members of Transportation Infrastructure should be actually advocating for a moratorium on any of the courthouses that are in the 5-year plan, pursuant to the letter that's been referenced of August the 2nd?
Congressman, that is really a policy issue. GAO does not take policy positions such as that. My purpose here today is to talk about issues you may have to discuss or need more information with respect to the report we wrote.
But you have responded that there was no suggestion in there that there should be a moratorium.
We've made no suggestion. We've had no discussion of that in our report. That's correct, sir.
Did you take into consideration that if you did call a timeout, what kind of additional cost that, and how do you make up for that? I'm just going to give you a real quick example. Full disclosure is fiscal year 12, the San Antonio courthouse should be number 1, but they're in a building that wasn't even designed to be a courthouse. But I don't even want to get into the particulars of what's parochial and such, because this is really across the board. I will ask Professor Resnick real quick. I think I understood what you were trying to get to and such, but what about the criminal caseload? I mean, in my area, that's substantial. And you're not going to have that taking place anywhere outside of a courtroom setting.
No, I'm actually for trying to get more things into court, but the numbers, the 300 to 350,000 filings a year include civil and criminal. And I think what you're pointing to is exactly the great disparity of density of use, border states being in very acute need for space and some other areas of the country with less. On the courtroom sharing, one courtroom that's not been much mentioned, a Court of Appeals. I've argued in several of them, as I'm sure others here have, and those are very scheduled spaces that are often not used, for example, in the afternoons in some circuits, sometimes for a couple weeks at a time. And if we're looking for more space and capacity in the system, one could look to consider how to use all the rooms. But I want to be very clear. The hope is that you will look at the flattening filings nationwide and say that's a problem that Congress needs to fix.
Now, and I understand
helping people come into
and that definitely impacts what our needs in identifying them. But I'm going to ask Judge Ponser and Judge Conrad. I mean, if you have a moratorium while you're trying to address the concerns of certain members of the committee that does have jurisdiction over construction, what could be the potential consequence of that? I know what it is for San Antonio because we've got a land swap going with the city of San Antonio, and they're demolishing the police department in order to make room for the federal courthouse, but then that has to make available the building in the round. We have, you've been to our courthouse. It was part of Hemisphere 1968. It was an exhibit building. But what's the danger of the moratorium? I mean, what does that mean to the courts? What does that mean to the federal budget?
I truly hope that this does not happen, because it would be devastating in 15 to 20 cities where these projects are waiting. We have sites that have been purchased. We have designs that have been developed. We have an opportunity in this economic climate to save millions and millions of dollars if we can get going on our construction. The economic consequences are tremendous. The Salt Lake City Courthouse, as I said, it's shovel-ready. It's designed. They have a site. They are ready to go. The money has been appropriated. We have rebid the project and saved $25 million if we can begin the project now. The San Antonio situation is replicated over and over again in the country. And that's just the economic and logistical consequences that we will face if there is a moratorium. The impact upon human beings, flesh and blood people who need access to courts. In many communities, the state courts are overwhelmed. The only real access to justice has to be the federal courthouse. The door has to be open, the facilities have to be available, and there we have a problem.
Judge, I hate to cut you short. My time is up, and I don't want to make the chairman miss a vote, that's for sure. So I'm just at this point, and I apologize, Judge Conrad. Hopefully I'll never have to appear in your court, but I will yield back. Thank you.
Yes, I hope that I will not have to appear in your court also, Judge Conrad, under those conditions that you cited.
Bring a bucket if you do.
Yeah, I will.
If you have to.
And my hard hat.
Mr. Chairman, if you'll yield, Mr. Judge Conrad's family are good friends of mine, so don't be too hard on him.
Well, no, he's probably not deserving of such harsh treatment as he's been receiving as a federal judge. But I do want to thank all the witnesses for the testimony today. Without objection, you'll have 5 legislative days to submit any additional written questions, and I'm speaking of the members, which we will forward to the witnesses and ask that you answer as promptly as you can to be made a part of the record. Without objection, the record will remain open for 5 legislative days for submission of any other additional materials. I reiterate my concerns about justice not being run over in a misguided attempt to maximize efficiency in our federal courthouses. Again, I thank everyone for their time and patience. This hearing of the Subcommittee on Courts and Competition Policy is adjourned.